All right, we're gonna get started. Panelists will speak for 15 minutes each. Ashley will rigorously enforce that, and I will not add my own commentary to what they have to say. We'll just open it up to questions immediately. So our first presenter is Yang Liu, who's going to present his argument that while the National Firearms Act regulations of silence suppressors might be constitutional, the state absolutely, the eccentric minority of states that completely ban suppressor possession violates the Second Amendment. Take it away.
Good morning, and thank you all for listening. My topic today is about silencer regulation. Many of you are likely aware of the significant health benefits silencers, also known as suppressors, can provide. According to the Occupational Safety and Health Administration noise standard, imposed noise should not exceed 140 decibels to avoid the risk of permanent hearing damage. Now, most firearms pass this threshold without silencer, and large rifles and pistols can easily exceed 175 decibels. While some have downplayed the importance of silencers by pointing to alternatives such as air plugs, studies show that these tools alone are insufficient to prevent hearing damage from gunfire. For example, a study on Finnish soldiers found that air plugs often don't fade properly, reducing their effectiveness. Not only that, they can also interfere with communication between personnel and jeopardize hearing wildlife sounds and range commands, which increase risk of accidents. Historically, concerns about silencers being used in crimes have led some states to heavily regulate or ban them. However, as society has gained a better understanding of this technology, the connection between silencers and crime has proven to be weak. As a result, over the past 15 years, many states have relaxed their silencer restrictions. Since 2010, states like Maine, Michigan, Minnesota, and Vermont, once opposed to civilian ownership, have revised their laws. Other states that previously banned silencers for hunting, such as Louisiana, North Carolina, Pennsylvania, Arizona, and Wyoming, also recognized the unreasonableness of these restrictions and lifted them. Today, silencers are legal in most states for both possession and legal use, where citizens can own them by registering them under the NFA. While silencer owners still face some burdensome restrictions, like needing ATF approval for each interstate border crossing, the general trend is toward more favorable treatment of silencer possession, and for those who value both their Second Amendment rights and their hearing hairs. However, at this time, residents in 8 states, including California, Delaware, Hawaii, Illinois, Massachusetts, New Jersey, New York, Rhode Island, and the District of Columbia, still cannot legally own silencers. In Connecticut, while ownership is allowed, using them for hunting is not. My paper addresses these laws. In my paper, I argue that these state restrictions are likely unconstitutional and infringe on people's Second Amendment rights. Under the Supreme Court's Bruin test, courts should consider 2 questions to determine whether such laws are constitutional. First, does the law fall within the scope of the Second Amendment? And second, is the law consistent with this nation's historical tradition of firearm regulation? Now, regarding the first prong of the Bruin test, we do not yet have a Supreme Court precedent that directly addresses the constitutional status of silencers under the Second Amendment. There is only one precedent from the 10th Circuit. In U.S. versus Court, decided in 2018, the 10th Circuit Court of Appeals ruled that silencers are not protected by the Second Amendment. Relying on 2 18th century dictionaries and one from the 19th century. The court argued that silencers do not base upon the era definition of an arm. According to these sources, the term arm refers to, quote, weapons of offense or armor of defense, or anything that a man wears for his defense or takes into his hand, or uses in grasp to cast at or strike another, unquote. Under this definition, the court concluded that a silencer, since it is neither a weapon nor defensive armor, should be classified as a firearm accessory instead of an arm, and it held that firearm accessories are categorically unprotected by the Second Amendment. In reaching this conclusion, the court quoted Heller, in which Justice Scalia wrote, quote, The Second Amendment extends prima facie to all instruments that constitute bearable arms, unquote. The 10th Circuit, however, appears to read this as only instruments that constitute bearable arms are protected under the Second Amendment. This is not what the Heller majority held, and this interpretation is overly simplistic and problematic. First, this interpretation overlooks the Second Amendment's broader application to firearm accessories. A prime example of this inconsistency can be seen in the Garland case, which the Supreme Court decided earlier this year. While Garland focused on statutory interpretation rather than the Second Amendment, the court acknowledged that accessories like bomb stock indeed are entitled to protection. This decision exposes the flaw in the 10th Circuit's rigid dichotomy between firearms and accessories, where only the former are deemed worthy of protection. Second, the Supreme Court has long held that acknowledging a right often implies protecting the supporting or associate rights that enhance exercise of the primary right. For instance, in Griswold versus Connecticut, the court recognized right to privacy as a fundamental right, even though it is not explicitly enumerated in the Constitution. Justice William O. Douglas, writing for the majority, explained that several amendments, such as the first, third, fourth, and ninth, collectively creates both zones of privacy, unquote, that protect individuals from unwarranted government intrusion. This reasoning naturally extends to the Second Amendment. If the right to bear arms is acknowledged as fundamental, it logically follows that this right includes protections for firearm accessories such as silencers, which facilitate and enhance the lawful use of firearms. The Second Amendment was not solely designed to protect firearm possession, but also to ensure individuals could effectively use those firearms for self-defense, for hunting, and all other legal activities. Excluding silencers from this protection would only force individuals to choose between safeguarding their hearing and fully exercising their Second Amendment rights, an outcome that undermines the very fundamental purpose of the amendment. So assuming that silencers fall within the protection of the Second Amendment, we then move to the second prong of the Brune test, examining whether there are historical regulations that impose a comparable burden based on a comparable justification. Let's briefly review the history of silencer regulation first. Silencer was invented by engineer Harold Maxim in the early 1990s and patented in 1908. It quickly became the target of restrictive legislation in some states, driven by largely unfounded concerns linking to organized crime and poaching, concerns that have since been largely discredited. Beginning with Maine's total prohibition of silencer ownership on March 24, 1909, just 1 year after silencers were patented, several states, though a minority, began enacting silencer restrictions. By 1934, 16 states and the DC have introduced regulations, with 11 of them imposing outright bans and others restricting their use specifically in hunting. So the question now we have is whether these pre-NFA silencer restrictions can justify the current prohibitions. It's true that many of these pre-NFA restrictions share striking similarities with today's laws. Actually, 7 of the 8 existing state silencer bans originated during the era and remain largely unchanged. Likewise, Connecticut's restriction on using silencers for hunting dates back to this period and mirrors similar prohibitions across other states. However, the Brune Court made it clear that simply recognizing these historical similarities is not enough. The inquiry must go further. The court emphasized that laws must align with a broader national tradition to be constitutionally relevant. In Brune, the court pointed to cases like Texas' 1871 prohibition on carrying firearms without reasonable fear of attack, labeling such laws outliners. These outliners, according to the court, did not reflect a long-standing national tradition. In assessing whether a law is representative instead of constituting an outliner, Brune identifies 3 key factors. First, the law should not represent a legislative improvisations typical of frontier territories that permitted extraordinary government actions at odds with nation's established approach to firearm regulation. Second, it must have undergone meaningful judicial scrutiny grounded in correct constitutional interpretation. Finally, the law must have existed for a sufficiently long duration. When it comes to silencer regulations, the second factor clearly weighs against this path. These pre-NFA laws did not face any substantial judicial scrutiny, not to mention judicial reviews grounded in the correct original meaning of the Second Amendment. However, the third factor does support treating pre-NFA bans as a valid reference point, as these laws, though mostly already repealed, remain in force for a considerable period, often lasting till the 2010s. This distinguishes them from the shorter-lived outliners that Bruin considered, which usually lasted only a few years to a few decades. The critical question then lies in the first factor, whether these pre-NFA restrictions can be considered legislative improvisations. My paper argues that they indeed are. In a federalist system, states often lead the way in addressing emerging issues, such as those posed by novel technologies, serving as laboratories for legal experimentation. However, just because states often take the lead in regulating new technologies, does not mean these new technologies fall outside the Constitution's protection. In contrast, in cases such as Cateno versus Massachusetts, the Supreme Court has made it clear that the Second Amendment protects not only firearms existed in the founding era, but also modern innovations like stun guns. More broadly, one of the main reasons why the Supreme Court rejected the means-end scrutiny in favor of a historical test was that a long-standing national tradition offers a more reliable guide to the Second Amendment's origins and continuing significance. Blindly importing state-level regulatory experiments that lack meaningful judicial scrutiny into this historical analysis undermines its goal. It risks diluting the Second Amendment's importance by treating experimental state regulations that may or may not correctly reflect the original understanding of the Constitution as if to provide genuine historical precedent. Actually, a closer examination of the historical science regulations, particularly the trajectory of federal and state management, reveals that these pre-NFA era restrictions align more closely with the legislative improvisations described in Bruin than with a genuine long-standing tradition of science regulation within this nation. While a minority of states did impose science restrictions before 1934, it is notable that following the passage of NFA, very few states pursued additional science regulations. The establishment of NFA's registration-based federal approach effectively halted the trend of state-level science legislation. The few outliners include Delaware, which expanded a pre-existing hunting ban into a total silencer prohibition in 1937, and Arizona, which banned silencers for hunting in 1936. So this was later repealed in 2012. This abrupt halt in state-level regulation after the NFA's implementation states that even if there were valid reasons about silencers being linked to organized crime, the federal registration system established by the NFA was considered and proven to be sufficient. In fact, the NFA has been served as a reference point for the few states that choose to strengthen silencer restrictions after 1934. Connecticut, for instance, has maintained its hunting ban on silencers since 1970, but enacted additional regulations in 1976. However, these regulations didn't criminalize silencer possession outright, like pre-NFA approaches. Instead, they penalize the possession of unregistered silencers under the NFA framework. Thus, overall, no matter whether the NFA's regulatory model or the largely laissez-faire approach of most other states better represent this nation's historical approach to silencer regulation, or perhaps both could be seen as representative, it is at least evident that the NFA's registration-based approach, backed by judicial validation, better reflects a national tradition of firearm regulation that is in harmony with the Second Amendment, when compared to the isolated and untested silencer bans enacted by states prior to the NFA's adoption, which are better categorized as legislative improvements. Accordingly, in light of this background and after considering the principles outlined by the Supreme Court, my paper concludes that NFA represents the most stringent form of silencer regulation that might be justifiable under the Second Amendment jurisprudence. Therefore, current state laws that ban silencer possession or use impose an unconstitutional and excessive burden, one that is inconsistent with this nation's historical tradition and firearm regulation. Thank you.
Our next speaker is Matt Larosiere, and I will say, having been working on this issue since the 1980s, when I read a new law review article on something involving gun policy, I typically find, oh, I already know a lot of what's in here, even if there's some novel arguments. This was not that. This is incredibly technically sophisticated article and will be, I think, very valuable across the board to regulators, to lawyers and to courts. Some of the things it describes are rather obscure little trigger gimmicks, but there's also a detailed description of the mechanics of how an AR semi-automatic is internally different from an M16 machine gun. And, you know, Steve Halbrook knows a lot of this, and you can find it in condensed form in the Firearms Law Desk book, but this is the uncondensed full encyclopedic version.
These days, you know how to make a girl blush. But thank you all so much. So I'm going to be talking about specifically how machine guns have been treated differentially to other National Firearms Act weapons. And, you know, you might be aware of the Firearm Owners Protection Act, of the Hughes Amendment that prevents, you know, new machine gun registration. That's only the start of it. There's an aggressive history of machine guns getting one treatment, not just with the NFA, but with the courts as well, and everything else being treated separately. And there's kind of this homism that gets repeated, that these are dangerous and unusual, and that's why they have to be treated in this specific way. You know, and that's why, oh, it's okay that you can't register a new one. However, and ask me how I know this, you can right now, as an individual, register a 40mm grenade launcher, and they will, without any fuss, grant you that. I have one mounted to my A2 carbine that looks very cool. I don't do anything with it, because what are you going to do with that? But the ATF has no problem letting you have a grenade launcher, an anti-tank projector, a landmine, a flamethrower, but a gun that can shoot not even faster. Machine guns can't even shoot faster than ordinary semi-automatic firearms. In fact, if you read my paper, you'll find that they're mechanically slower, and they have to be because of rate-reducing mechanisms that are necessary in lock-breech firearms. I won't get too deep into that, but the issues are an inconsistent approach to what is a machine gun, where the lines are drawn. And the ATF had previously done a good job of very publicly saying, this is where we think the line is. And for everyone, you know, in the industry that this might have upset, we're not going to apply this to you looking backwards. Going forward, this is the new rule. This is best explained in the case of the AR-15. The AR-15 kind of is a microcosm of all of the weirdness that has happened in machine gun litigation. And before I start, I don't know how many of you will be foolish enough to join us in gun policy as a career, but for those of you who do, I want to stress something. The anti-gun side has begun taking the position that the AR-15 is not principally different from a machine gun. They're technically correct. Do not respond to that with the homism of no, the AR-15 is semi-automatic and the M16 is fully automatic. You are wrong on every front. You are wrong technically. You are wrong in every single way. The M16 was adopted as the Colt AR-15 Model 604. It's an AR-15. Armalite never made a single AR-15 pattern gun. The real Armalite in Hollywood never made a single AR-15 pattern gun that was not select fire. The distinction is between a semi-automatic AR-15 and a fully automatic AR-15. That is factually correct, and you will be able to win your arguments making that distinction. If you just begin saying, no, M16 is fully automatic, well, what about every single Model 604 that was exported to every other country? What about the Type 65 from Taiwan? What about all of these other AR-15 derivatives, right? So that point I just want to stress because it is too often repeated and then too easily struck down. The first semi-automatic AR-15 pattern firearm was the Colt Comanche, 1963 and 64. About 5 years after the pattern was standardized. And they made some minor changes, Colt did, to just discourage fitting of fully automatic parts to the gun. This was sent to ATF's predecessor, the ATTD, and ATTD had no problem with it. we'll get back to what was in this gun. But the gun had just been modified so that the selector would not rotate all the way to the full auto position. Gun still included an M16 disconnector, still included well, and we're using that term, right? Model 604, we'll call it M16 disconnector, still included a M16 trigger, still included an M16 bolt carrier. The hammer was modified, slightly shaped off. And ATF said, there's no problem with this. This is great. We would like it if you made these small changes. They made the takedown pins so that you couldn't swap uppers, right? And they changed the bolt carrier a little bit. This gets sold for a while. People then begin to get access to military surplus M16 parts. And it becomes apparent that people have an interest of installing these in their semi-automatic rifle, right? So out comes the drop-in autoseer, which we've heard mentioned twice today. The drop-in autoseer is a term part. The drop-in autoseer specifically, it's 3 parts. It's not a single part. It's a combination of parts that imitate the M16 Colt AR-15 604's functioning of an automatic series. So you need all of the other parts of that gun. Further, people had been making these and kind of selling them in shotgun news, which is when you get into firearms policy, shotgun news is the source of a lot of hot water for gun owners. They're sold in shotgun news as just like trinkets, right? And ATF finally gets hold of these. They examine it and they say, hey, that's a machine gun, right? That's a combination of parts designed and intended for converting weapon to fully automatic. We understand that, you know, previously the position was that you had to have these other parts, and so without those it wouldn't function. So we're not going to treat any of these made before this date in 1981 as a machine gun. So that was actually ATF trying to throw a bone to these companies who had made them. And I believe it was the Seventh Circuit said, no, you can't do that. If it's a machine gun, it's a machine gun. So ATF locked itself into this position on the drop-in autoseer. So then ATF clarifies, well, how do you make sure your semi-automatic AR-15 is not a machine gun? And so they release a letter that's now still on the website, which says, here's how to configure your semi-automatic AR-15 to avoid all of these problems. ATF says, keeping in mind its determination of the autoseer, it focuses on those parts that would work with the DIAS, which are those Model 604 M16 parts. It says, if you want to avoid this, make sure you have a Colt SP1 trigger, Colt SP1 disconnector, Colt SP1 bolt carrier, and you're all good. Well, that creates a problem. One, what is a Colt SP1 disconnector? What is a Colt SP1 trigger? As I told you before, the Comanche, the first model of the Colt SP1, just used Model 604 parts. In 90% of the parts that ATF said, stick to these, the first 10,000 or so guns had M16 parts there. So we have no idea what they're talking about. Realistically, the majority of production had ones that were modified to prevent interacting with other M16 parts. So we can kind of get at what they're saying. They're talking about the ones that were made in the 70s and 80s, the most common of these relatively uncommon guns, have these parts to make sure you're A-okay. Well, then the Lightning Link comes out in just before 1986. And you'll hear a lot of talk about these. It's probably the most common illicit machine gun conversion device. Could be a coat hanger, it could be two little pieces of steel that drop into a otherwise semi-automatic AR-15 and make it fire only automatically. There's a minor detail. These are designed to work exclusively with the very parts that ATF said, put in your gun to make sure these don't, it's not a machine gun. So ATF actually never releases a public determination on the Lightning. Whereas with the drop-in autoseer, we know exactly which parts they consider the machine gun, exactly which parts should be serialized. With the Lightning Link, we're left spinning in the wind. We only have, through Freedom of Information Act requests, which part, you know, whether you can have the lower part or the upper part. They've never been public about any of this. And so that's a huge problem. And I think the problem is because it was so focused on the drop-in Larosiere, didn't foresee the lightning lane. And now there exists a part that works specifically with the parts they said will keep you safe. Instead of giving us guidance, what they've done going forward is, and I firmly believe that head office does not target people or anything like that. But there has been a pattern of behavior where people who seeking to make products that, you know, could be used in one way or another, the first time a new interpretation of machine gun is tested is with their criminal prosecution. Okay. And that's a huge problem, and it happens very, very often. And we are talking about edge cases where we're dealing with items that don't meet the specific definition of items of the act. As our dear friend from ATF did mention, there was the coat hanger incident. That was a bit silly, right? But there is a part of the law that says if it's one part, it's a single part, designed and intended, it must be designed and intended solely and exclusively for converting a weapon into a machine gun. That's distinct from a combination of parts, which must only be designed and intended. So again, there's at least a reasonable question as to whether a hanging use, right, survives solely and exclusively. And so it's probably inappropriate that these be tested for the first time in criminal prosecutions, but it appears that the way the law is developed, the government at least feels that their hands are tied and this is the only way they can do it. The biggest concern, though, is that lightning link type devices now exist for every category of AR-15. And here's the other concern. ATF says that a gun to be totally safe should have these parts. I would challenge any of you to go out and purchase an AR-15 that has any one of the parts that ATF has identified as being the safest, because no one bothers. They go with the cheapest stuff, and the cheapest stuff is the military overrun stuff that you can just cut the tail off of. You cannot, unless you're a collector spending thousands of dollars, get a gun that ATF tells you is compliant. And the hugest problem is that we have no idea how some of these devices work. And in fact, the ATF has admitted in many prosecutions that, well, they aren't actually firing automatically. It's disabling the disconnector and the hammer is following the bolt home. If you want to really know what that means, you can read my paper. But what that is incidental, occasional, repeated fire with a single pulling of a trigger, not as the result of a self-acting or self-regulating mechanism, but of a dangerous malfunction. If it is the case that a malfunction that could potentially explode the gun makes it a machine gun, if two malfunctioning shots go off, specifically in the case of the hammer fall, it has to be the case that every single AR-15 in this country meets the definition of a machine gun because it contains the frame and receiver of a machine gun, right? We went through all those definitions. It doesn't have to shoot automatically as long as it has the same receiver that shoots automatically. And there's no difference in the receiver between an AR-15 that has its disconnector cut off or is just missing its disconnector and an M16 lower receiver, an AR-15-604 lower receiver, or a Colt SP1 lower receiver. All of them are the same receiver. So my position is that we need more clarity in these interpretations and that they need to follow a consistent thread. I will freely admit that the ATF has previously attempted to do that, and they were frankly prevented from doing so. So what we need is the court to step in and frankly, pull the reins. If we're going to decide that new fringe devices that may be a single part but have other purposes to be a machine gun conversion device, well, Congress is the one to say that. Certainly not a jury, certainly not a judge, and most certainly not an administrative agency. Thank you all so much for your time. It's my fun a little bit.
In my career of litigation and scholarship, I've written about the original meaning of many different provisions of the Constitution, which don't necessarily have to determine the outcome of the case, but at least anybody ought to want to know the original meaning and take that into account. Of all the things I did when I was doing the Obamacare cases. The thing that I found so hard, I decided just to give up, was original tax meaning. And the distinction between, for example, direct taxes versus indirect taxes. A much braver man than I is our next speaker, who will explain why at least part of the NFA may be inconsistent with the original meaning of the tax power.
My name is Charles Eldred. I'm with the Texas Attorney General's office. Like I would say, I've got my own personal capacity today. I don't necessarily represent the views of my office or of Ken Paxton, the Attorney General of Texas. With that out of the way, unlike I think a lot of people in this room, I'm not really a gun person. I don't really know a lot about guns. I'm a city boy. I'm not a hunter. I didn't know anything about gun law until about 3 years ago when, as part of my job, I got assigned to work on a case that had to do with the making of firearm suppressors for personal use, as opposed to manufacturing them for sales. And knowing nothing about it, I read Mr. Halbrook's book, Right to Bear Arms. I read Professor Mascari and Koppel's the case book. And I was very interested and surprised to learn that the making tax is actually, the making is a taxing statute, it's regulated by a taxing statute from 1934. Actually, it's 1968, but that's another story. And I had worked in state tax law for 8 years, and I thought that was really interesting and seemed wrong to me that they do all this stuff as an exercise of taxing power. But I found out that in the 30s, the Supreme Court had said, yeah, they can do that, no problem. And I kind of moved on from it. But then I saw the call for papers for this event, and I thought, well, I'm gonna write that down, write down my argument, see if it works. It would be write down. So is the National Firearms Act really a proper exercise of the taxing power of the Constitution? And that's what my paper's about. First of all, there's two easy arguments to say that it's not a proper exercise of taxing power. One is that you can't tax the exercise of constitutional rights, and since 2009, at least the right to keep and bear arms is a constitutional right, an individual constitutional right. But yet the NFA taxes the right to keep and bear arms, at least somewhat. That seems like an easy argument to make. It hadn't made the Supreme Court yet, as far as I know. The other one is from Bruin. There's no historical precedent for arms being taxed by states or the federal government. I believe the first tax was in the 1840s of Bowie knives. The first federal tax, I believe, is 1930s. So there's the historical precedent is not there. Those are the easy arguments to make. I just have a funny feeling that there's not 5 votes in the Supreme Court right now to say, you're right, the NFA has been unconstitutional all this time. I don't believe that's going to happen, but maybe I'm wrong. So I had other arguments coming from my tax nerd background, probably only a tax nerd can like. So I'm going to go over those real quick. This is I consider this paper to be kind of a start of a dialogue. I may be wrong. I'm not totally confident in everything I'm saying, but I haven't seen anyone even try to analyze these things under taxing power. So here goes nothing. First of all, it's been not long known that to exercise taxing power, you have to, at one, collect revenue. So if your statute does not collect revenue, it's not an exercise of taxing power. You can also have provisions that help you collect revenue. So the requirement that you submit a tax return along with your income tax, that's okay. It's necessary proper to collecting taxes. Even though the tax return does not collect revenue, that's okay. So that's been around for a long time. My paper goes into this. There's also, you can use taxes to regulate in some sense. That goes way back. Cigarette taxes are probably more really about regulating cigarette use than raising revenue. And that is a proper exercise of taxing power as long as it collects revenue. And then there's the Sebelius case that Professor Koppel mentioned. That's the Obamacare case in 2012, where to many people's surprise and outrage, the Supreme Court found the individual mandate of Obamacare to be a proper exercise of taxing power, although not a proper exercise of commerce power. The opinion says a lot about taxing power that is interesting. You apply to the NFA. First of all, the majority confirmed you have to collect revenue, or else it's not an exercise of taxing power. It can't be a direct tax as opposed to an indirect tax. I'll come back to that. And they also said it can't be a penalty. There's a case from the 20s about, they tried to ban products made by child labor by taxing these companies out of business. And the Supreme Court back then said, no, that's not tax power. You're just penalizing them for using child labor. Can't do that. And Cecilia's case reaffirmed that. So it's possible for a tax to be a penalty really and not really a taxing power to this day. So let me take a little aside to direct taxes, indirect taxes. The Constitution says direct taxes have to be apportioned among the states. Indirect taxes apparently do not. It's easier to describe what an indirect tax is. A sales tax is not an indirect tax, it's an indirect tax. So the transfer tax of the NFA is an indirect tax. And things like tariffs are indirect taxes. Basically taxes on transactions are indirect taxes. There was a debate about whether the income tax is an indirect tax or a direct tax. And we solved that debate by just saying, well, income taxes don't have to be apportioned like direct taxes do. And I'm getting to what direct taxes are. And direct taxes, we know three things that they are. A capitation tax, where you just pay $100 a year because you're alive. Those taxes existed in early America in some states. A tax on real property. So I think many states have real property taxes. Federal government does not have real property tax. I think that's a direct tax. And a tax on personal property is also a direct tax. Just having the property, like a tax on a phone. You got to pay $100 a year to have a phone. That will be a direct tax. And a direct tax has to be apportioned among the states. If you go back to your Articles of Federation, you may remember that the states were told you owe this much money to the government. That's how you had to raise a direct tax. So if they want to make a direct tax on phone ownership, they'd have to say, Wyoming, you owe us $1 million. Texas, you owe us $20 million. New York, you owe us $18 million, whatever. It has to be apportioned among the states by population. And you've never heard of those taxes because they don't really exist. They've only done it 3 times. And they did it in 1798 once. That caused a rebellion. These taxes are really hard to collect, and they haven't even tried in a long time, unless you count the income tax. And I'm going to get that's going to be important later. In fact, so let me talk about my nerdy arguments. As was talked about before, you can't just make a suppressor or make an NFA weapon. You have to ask permission to make it first. You have to apply for permission to make these weapons. Similar with transfer, you can't just transfer, you can't just go buy them. You have to ask for permission to buy them first. The application process is, to me, not a proper exercise of taxing power. It does not collect revenue. It doesn't help you collect revenue. It actually reduces revenue because people who are felons who apply to make a weapon or transfer a weapon are going to be denied. ACF's going to say, hopefully, you are not allowed to own these things, so I deny you permission. So I deny you permission to pay the tax. How many of you have ever asked to pay a tax? I have not done that. I've never, unless you've done a Form 4 or Form 1, I guess. It's really odd to me to think that you have to pay permission, ask permission to pay a tax. It seems like not an exercise of taxing power. I think the application process of the NFA is not an exercise of taxing power, and I think it's probably subject to constitutional attack that way. There's also, the NFA requires that importers be register, and that has massive restriction on importing NFA weapons. Those don't raise revenue either, I think, because basically the only weapons you can import are the kind of weapons that cannot possibly be subject to a taxable sale. So if I import I can import a weapon, for instance, to sell to the government, but if I sell to the government, that's not a taxable sale. So those two things also seem like not exercises of taxing power because they're not raising revenue. They're just not a tax. The occupation tax. Okay, so if you're a dealer, a manufacturer, or a blanket, I forgot. Importer, thank you. Those 3 people, as was discussed before, have to pay an occupation tax. It's kind of like a capitation tax, a certain amount of money you pay every year. Well, a capitation tax is a direct tax. It's an occupation tax, a direct tax. I don't have case law saying it is, but I think it's closest to a direct tax, closest to a capitation tax. So I think the occupation tax is a direct tax that has to be apportioned among the states, which of course really means it's not going to be collected. There's no way they're going to say, Wyoming, you have to pay $500,000 a year or whatever it is, collected from the dealers, manufacturers, and importers of NFA weapons. So I think the occupation tax is also unconstitutional. As a taxing power, I should say, a lot of this stuff could be reenacted under the Commerce Clause if they really wanted to, but they haven't yet. So it's subject to attack in my mind. The making tax is also, this one's a tough one. So the making tax is, I have a bunch of stuff, I have a bunch of personal property in my possession that I'm allowed to possess. I'm gonna make it into an NFA weapon. I have it, that seems like that's like a tax on personal property to me, and therefore it seems like a direct tax to me. Again, I don't have case law on that, I don't have precedent, but that's the argument, and if someone can tell me why I'm wrong, I'd like to hear it. You could say that the making tax, the federal government did pass a tax on the production of alcohol in the 1790s. That might be precedent for it not being a direct tax, but we'll see. The transfer and making tax are $200 each. To me, that's just for religious penalties. Those taxes were designed to make people not buy guns, or really to entrap Al Capone and his friends. So they're not really taxes; they're penalties. And the NFA also requires, when you apply, the application process to make or transfer an NFA weapon results in your weapon being registered. Also, your weapon has to have a serial number on it. Those seem purely regulatory to me, not really in aid of collecting taxes. So again, I think that's not an exercise of taxing power. That's 10 ways I think the NFA might violate the Constitution because they're in excess of taxing power. In addition to the more easy ones, which is you cannot tax the exercise of a constitutional right, and there's no historical precedent for taxing keeping and bearing arms. But that's my basic paper. I think I will give my rest of my time back. Thank you.
Thank you. Some of the older people in the audience or online may remember the Romper Room television show in the 1960s, where the host, Miss Jeannie, for preschoolers, would hold up a magic mirror, which she said she could see the people watching the show. And she later sold that to the FBI for a huge but we don't have one of those. So if you're online and you would like to ask a question, write your question in the Q&A feature online. You law students may have come across Supreme Court Justice Felix Frankfurter, in my view, not a particularly impressive Supreme Court justice, but before that, he, as a Harvard law professor, founded the field of administrative law. So all of you who ever taken administrative law, it's because that was a field that Professor Frankfurter identified as something worthy of study as its own subject. Stephen Halbrook is the founder of Second Amendment and arms law as an independent subject worthy of study. And if it were not for him, the Moxery, Copel et al. Textbook never would have existed. His influence in the field is just gigantic. He is my sometimes co-author and longtime friend, and it is a great honor to introduce him to you.
Thank you, David. It's a real pleasure to be here. This is the first conference ever, as far as I know, about the NFA, and it's an important subject. And the NFA was always something you kind of hold your nose at. You know, people would say, well, these are gangster weapons, and who would want them? And you know, let's leave the subject alone. So I think this is a real first step in delving into these issues in a lot more detail. So think back to 1934. John Dillinger had just escaped from jail using a wooden pistol. And that was great embarrassment to law enforcement authorities, including the FBI. They were really out to get him, and they would get him. I think 2 months after the NFA passed, he was shot dead by FBI agents outside the movie theater. His girlfriend had betrayed him. She was the lady in some people say red, but in the movie is I think pink, but whatever. that's what a lot of people were real concerned about. In 1934, the House Ways and Means Committee had a really long hearing, actually 2 days of hearings, but I think the transcript comes to over 150 pages. And it's very enlightening. I recommend reading that. I'm pretty sure it's online. This is really the only explanation we have about the NFA. What were the considerations? Because after it was, reported by committees in the Senate and in the House, you have these 2 very short committee reports that are really unenlightening. And the debate over the NFA in the Congress, the floor debates, was virtually non-existent. So think about, the committee comes to order. Homer Cummings is an Attorney General of the United States. He's FDR's crime guy. And he appears throughout during the hearings, although he has an assistant, George Keenan, who was Assistant Attorney General and had been prosecuting some of these high-level gangster cases before the 1934 hearings. He carried the ball when Homer couldn't be there. Homer is no relation to Samuel Cummings, by the way, one of the greatest firearm importers of all time. So right at the very beginning, you've got the NFA bill, which changed drastically during the course of the hearing and what ended up being the compromise version. You have Attorney General Homer Cummings saying that the constitutional basis is the power to tax. The Harrison Anti-Narcotics Act had been upheld by the Supreme Court. That was the precedent where to sell morphine or be in the morphine business, you had to have these approvals and registrations and payment of taxes. Supreme Court felt that was adequate. The government couldn't just ban drugs. And by the same token, Homer Cummings immediately said, well, we know we don't have the power just to ban firearms, but we do it under the tax power. And of course, that it involves the registration system where registration would be justified because that shows who's paid the tax. You can see the logic to that. I thought that was very enlightening, some of the points you made about the tax power, other aspects of the NFA, like the application. I would think serial numbers might be kind of like the registration form. You can say, you can put this in a footnote, that proves that firearm is registered. If it doesn't have a serial number, you wouldn't be able to impose that. But yeah, I think those are some interesting ideas that have been proposed here. I'm going to just talk about the tax power first in terms of the hearings. It's pretty simple, and the $200 tax, that was the price of a Thompson submachine gun, and the purpose was to basically, make it very difficult for people to purchase those. Silencers at that time, I think, were about $6. Nobody was going to pay that kind of tax for a silencer, particularly when you look at the equivalent to what $200 was then, and you look at the typical income level of people. I've got this in my article. I don't memorize figures too well, but the typical income level was pretty low compared. I mean, $200 will be a big part of it for the year. So Zinzinski, United States versus Zinzinski, upholds the tax as applied to the special occupation tax for dealers. This was in 1937. The Supreme Court upheld that part of the tax. And if you look at the Seventh Circuit decision that preceded this, the Supreme Court's decision, you'll see some more detail about the case, and it's very interesting. But the main point about Zinzinski, it said Congress didn't do anything that didn't have the power to do in terms of, it's not trying to regulate conduct. And I think it's a very important point that Congress is not like declaring these weapons to be evil, wicked, mean, and nasty. It's only taxing them, And you have to close your eyes to any motivations. And that's what the courts have lost sight of up through today. Yeah, these are gangster weapons and we should impose higher penalties. It's in any other weapon. It's a revolver with a smoothbore barrel, which is totally inadequate as any kind of weapon, but it's required to be registered. So it's a felony to possess it. So Zizinski was cited in the Obamacare case as it shows its continuing vitality. And that issue got the government into a little bit of trouble in a 1990s prosecution that I handled, United States versus Rock Island Armory in the Central District of Illinois. 922-0 had passed, and so that was the ban on machine gun. So ATF would not collect the tax payment and would not register. And so that undercut the constitutional basis of the NFA, because prosecutors were still charging people for machine guns under the NFA provision, not 922-0 necessarily. And so the district judge wrote a wonderful opinion, it mostly came from my brief, making that point that he granted our motion to dismiss because there was no adequate constitutional basis of the tax power in a law, that there was no possibility of any revenue being raised. And so I think the 10th Circuit adopted that reasoning, but the U.S. Attorney's Manual told prosecutors just prosecute under 922-0 if it's a machine gun case. All the other NFA weapons you can continue under the NFA, but 922-0 for machine gun cases, then you avoid that. That created its own problem. That was the first firearms law that had no interstate or foreign commerce nexus. It's a ban on mere transfer or possession. And that was litigated very hotly after these 922-0 cases came up. And there were a number of dissenting judges like Samuel Alito in the Third Circuit. Lopez had been decided by the Supreme Court, invalidating the Gun-Free School Zones Act. There was no basis for that in the commerce power. The Fifth Circuit took that issue in bonk, but it came out as 8-8. And the lower court the 3-judge panel had upheld the law, so that stuck. And so that probably will never be litigated again, but gee whiz, if Congress were to pass a bump stock ban, claim their machine guns, so they have to, that's hundreds of thousands of felons. So I don't think I don't know if it's going to happen. I won't predict. I want to mention the first civil case on the NFA was Thompson Center Arms versus US, which I litigated. And only recently the bump stock case, that's the second civil case in the Supreme Court on the NFA. The thing about gangster weapons, Thompson Center Arms involved a pistol, a single shot pistol, very large, had no potential criminal use. It's just for hunting and target shooting, and a carbine kit, a long barrel and a shoulder stock. You could use the frame or receiver from the pistol and make it into a carbine, and inscribed on the stock was a warning: do not assemble with a barrel under 16 inches. And so the court came down on our side under the rule of lenity, and that case still has a lot of utility for that reason. The Second Amendment was really a non-subject. I'm not going to talk about the case law. You've already heard some of that. You've got your own analysis, but we had Miller, we had Heller, and of course Bruin. And so you can make a lot of Second Amendment arguments about the NFA. What I want to focus on in the remainder of my remarks, though, would be sausage making at the NFA hearings. They started out, number one on the list of NFA firearms was going to be pistols and revolvers. It went into shotgun, which will be 16-inch barrel limit. Any other concealable weapon, or a muffler or a silencer for any other concealable weapon, not all silencers, or a machine gun. The NRA got pistols and revolvers taken out. They said it was gonna be another Volstead Act, prohibition, everybody's gonna become a criminal, it's not gonna be obeyed. SBRs, they were not in the original bill. So this kind of a knucklehead Congressman, Harold, and I say his name right, Knudsen, I think is his name, from Minnesota. He was worried about hunters being accused of any other concealable weapon, so why don't we put a limit on barrel length for rifles, and 18 inches. And it took Cummings by surprise. He said it was kind of like, well, okay, if you want to put it in there. He never claimed there was any criminal issue there. But when the final bill came out, that stayed in there, but pistols and revolvers came out. So you have this irrationality. Little rifled arms are not restricted under the NFA. Big ones are not, but medium-sized ones are. Short barrel rifles that are not concealable by and large. Why? So that's the sausage making there. And then the other part of it, silencers. Silencers were in pretty wide use for something that had just taken off, and there was never any claim, just as with short barrel rifles, there was never any claim in these hearings that they were useful for criminals. I found one member of Congress that made an adverse comment about silencers. Think about the hearing protection that we could have had all these years. I know I've had hearing loss, and anybody in here that's like my age, I mean, you definitely have. None of us used to use even earmuffs. And of course, earmuffs aren't even that good. So it was really a lost technology. Maxim developed suppressors, mufflers for automobiles and industrial products and all kinds of other uses like that. Homer Cummings was not satisfied with the 1934 law, and the rest of his service as Attorney General was on a crusade to get all firearms required to be registered. And he was bickering back and forth with Keenan, who still worked for him. Keenan was saying, well, okay, if you require registration of all firearms, and maybe it won't be under the tax power, it would not be under the Commerce Clause, that would never fly. So he didn't protect that part very well. But he said, national security, we have to know who has the guns, so if we have an emergency, we know who to go to. So that's basically how these different items got in the NFA. The SBRs are the only ones that have been subject to less regulation. It went from 18 inches to 16 inches. There's a lot of, just thousands of SBRs that are CNRs. Machine guns are not eligible for that. And I just want to close by making a plug for taking SBRs and suppressors out of the NFA. Neither one is used very much in crime. Paul Clark authored a study about suppressor use. They're very rarely used in crime. There are very few prosecutions. It would be a health benefit. They're in common use. 3.6 million is the last NFA figure that I saw, and I think that it might be more than that now. And so if you want the best argument for suppressor deregulation, and I'm not talking about total, they would still be in the Title I of the GCA, SBRs and suppressors if you took them out of the NFA. And by the way, if you look at crime data for use of any rifle, that's a lot lower than handguns. But the best advice or recommendations for suppressors come from Europe. The UK, the Home Office, I mean, there's no right to gun ownership there. But they have authored memos where they encourage people to get suppressors for their guns. If you have a certificate for the gun, you can automatically get the suppressor with that certificate. You can order it by mail from the gun shop, or you can just go down and have it fitted, and they're very cheap, a lot less than in this country. So I think there's a lot to recommend it in terms of removing those two from the NFA. With the SBRs, I think the main argument is that it's not a crime gun. They're not used much, and it's irrational because they're just medium-sized rifle arms and the handguns are not under the NFA. And then with suppressors, there's every reason to look at it differently than it was at the time of the NFA in 34. Thank you.